Trespass to chattels is the sixth of the intentional torts taught in a 1L torts class. It is the second of the intentional torts affecting property, in this case, personal property. The tort is intended to protect the chattel owner's right to exclusive possession in his property. Let's start by defining what a chattel is. Black's Law defines chattel as movable or transferable property, personal property. It can be a laptop, a book, or a Range Rover. The key is that it is personal property not affixed to anything. Now that we understand what a chattel is, let's take to the restatement and see how this tort is defined. Welcome to Roman Manor. This lesson will explore the intentional tort of trespass to chattels. We will cover how the tort is defined, examine its elements, and go over a few examples. A word of caution, this course is intended to answer academic questions only. It is not legal advice. And with that, let's get to it. The Restatement Second of Torts, Section 217, describes the circumstances under which an actor commits a trespass to chattels. It states that a trespass to a chattel may be committed by intentionally A. Dispossessing another of the chattel, or B. Using or intermeddling with a chattel in the possession of another. From the restatement, it's clear that this tort requires the actor to dispossess another of their chattel, or to use or intermeddle with the other's property, thereby interfering with the true owner's exclusive right to control the chattel. The Restatement Second of Torts, Section 218, describes the circumstances under which liability to the chattel's owner arises from the actor's trespass. It states that one who commits a trespass to a chattel is subject to liability to the possessor of the chattel if, but only if, A. He dispossesses the other of the chattel, or B. The chattel is impaired as to its conditions, quality, or value, or C. The possessor is deprived of the use of the chattel for a substantial time, or D. Bodily harm is caused to the possessor, or harm is caused to the person or things in which the possessor has a legally protected interest. Stated more simply and concisely, to prove a prima facie case for trespass to chattels, the plaintiff must show that the defendant intentionally acted to interfere with the plaintiff's property right in the chattel and cause damages to it. Now, let's dig into the critical pieces composing the definition. This requirement is integral to all intentional torts. Simply put, the tortfeasor must have acted with intent. The Restatement Second of Torts, Section 1, states that a person acts with the intent to produce a consequence if A. The person acts with the purpose of producing that consequence, or B. The person acts knowing that the consequence is substantially certain to result. As we saw with trespass to land, it is largely immaterial if the defendant mistakenly dispossessed the plaintiff of his chattel. All that matters is that the defendant intended the action which interfered with or dispossessed the plaintiff of his chattel. Section 217, Comment C, gives some insight into this concept. It states, in part, that it is not necessary that the actor should know or have reason to know that such intermeddling is a violation of the possessory rights of another. Thus, it is immaterial that the actor intermeddles with the chattel under a mistake of law or fact which has led him to believe that he is the possessor of it, or that the possessor has consented to his dealing with it. Again, this tort's purpose is to protect the plaintiff's right to possession of the chattel, so any act by the defendant harming that right suffices as interference. Generally, this means the defendant will have done something to either interfere or intermeddle with that property right, or the defendant will dispossess the plaintiff of her chattel outright. The Restatement Second of Torts, Section 217, Comment E, gives some insight into this aspect of the tort. It provides that intermeddling means intentionally bringing about a physical contact with the chattel. If such intermeddling with another's chattel is done without his consent and without any other privilege, the actor is subject to liability for harm thus caused to the chattel. Section 218, subsection C, provides that liability to the chattel's true possessor can attach to the intermeddling actor when the intermeddler commits the tort for a substantial time. but what constitutes a substantial time sufficient for liability to attach? Section 217, comment on Clause C, provides that the deprivation of use not amounting to a dispossession necessary to render the actor liable for his use or other intermeddling with the chattel of another without the other's consent must be for a time so substantial that it is possible to estimate the loss caused thereby. A mere momentary or theoretical deprivation of use is not sufficient unless there is a dispossession. Nominal damages are not awarded in trespass to chattel actions. Remember, the interference or dispossession of the chattel must be such that damages can actually be calculated. Mere moments of dispossession will not be enough for this to occur. And with that, let's dig into a few examples. Paula and Diana are law students. Like most law students, they each own a laptop that they take back and forth between home and class in the various areas in which they study. Here, Paula and Diana were both studying at their school's library. Both women brought their laptops with them, as they do every day, and sat at the same table to study. Paula, after several hours of studying, went to get some coffee across the street at the business school. She left her laptop closed, along with her books and a backpack. Diana, realizing that Paula was gone, and knowing that the notes on her laptop were much better than hers, decided to take Paula's machine and access the notes. She didn't intend to keep the laptop, only to possess it as long as it took to get the notes. Under these facts, it's clear Diana committed trespass to chattels. She intentionally acted to dispossess Paula of her laptop in order to get the data inside. Even if she intended to return the machine, for the time she possessed the laptop, she was committing a trespass to Paula's chattel. Let's switch the fact pattern up a bit to illustrate a different point. Paula and Diana are both studying, but it was a cold day, so both women wore jackets to protect them from weather. Unbeknownst to both, they actually owned the same jacket, manufactured by the same outlet, the same size, even the same color. Both students took their jackets off while studying in the library. Several hours later, Paula went to use the restroom, and Diana decided that she was done for the day. The two had sat next to each other, and in Diana's tired state, she mistakenly grabbed Paula's jacket, put it on, and walked to her bus. Under these facts, Diana has committed a trespass to Paula's chattel, the jacket. Her mistake, or rather her confusion as to which jacket was hers, is insufficient to obviate her intent. She intended to take the jacket she actually took, and in so doing, she both interfered with Paula's jacket and dispossessed her of it. That's it for this lesson. If you found it helpful, give the video a like and subscribe to the channel. Leave some comments below and check back often for more content. As always, thank you for visiting Roman Manor and have a lovely day.